Alex here with part 34 of the My Docket series on child custody and visitation. I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of this series. Two things that I will quickly glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally closed. It's over. It cannot be reopened. My ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to provide my viewers with one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off in part 33 with me filing a motion to have both myself and my ex ordered to file Form 8332 with the IRS. The purpose of the form is to clearly outline which parent can claim a child on which year. And it is typically used to alternate years. So for example, I would claim the child on 2020, my ex would claim him 2021, then I would claim him 2022, etc., etc. Now, the default position of the IRS is that the parent who has the child for more time is the one that is supposed to claim the child, and that, would presume every year. But there is deference to the family courts, and what the family courts typically do is they recognize a parent who is paying child support as a parent who is financially providing for the child. So even though the child doesn't reside with them most of the time, that parent is still providing for the child just as much as the other parent is. And that's just sort of the presumption, I guess, as far as how the family courts see it. Some people will argue that child support doesn't really offset all of the costs that a custodial parent actually incurs, and really it's relative. It depends on the parent. Some parents get $2,000 in child support and they get plenty of child support, and that covers way more than what the child is actually using. Other parents get like $100, and that's not even close. And so it's not really that they get down to the exact, to the nitty gritty as to who's paying for the child more. They just kind of have this position of, well, you're both in court. We've given you both rights. One of you may have more rights than the other, but the other is paying child support, and maybe that's not as much money as the child needs, but to that parent, that's a lot because they're not, making very much income. And so the general idea, from what I've seen and, from the research I've done, is both parents get to share in claiming, the child on their taxes. So it has to be done through this form, because if you don't do it through this form and you have a high conflict ex, they'll just claim the child every year and tell you too bad, so sad. There are some low conflict parents who co-parent well, and they don't need a court order to do something like this. They just work it out every year. They figure out who's going to claim the child. Some parents even have a situation where one parent claims a child and then they split the money. Some parents can even do that. High conflict parents can't do that. I don't recommend that. And in my situation, the email response that I got back from my ex was, I have him for more time. Too bad, so sad. I'm going to claim him every year. So when she told me she was going to claim him every year, I decided that the only way I was going to have an opportunity to claim him was through the use of force. So filed a motion with the court, which is basically asking the court to exercise its power to force her to do something that she doesn't want to do. She responded by hiring an attorney, and the attorney emailed me quite a few times. There was some back and forth on this. The first request was that the attorney's client, my ex, didn't feel it was fair because she had him for more time. And I said, it doesn't matter if she thinks it's fair or not. This is what the law provides. And I wasn't talking about the IRS law, the federal statute. I was talking about how the domestic courts deal with it. And the attorney said, okay. I came back, or I went and talked to her, and I convinced her that if you claim him once every 3 years, then she'll agree. And I said, no, that's still not going to work. 40, 60%, that's close enough to half. No, this should be every other year. And the lawyer wasn't happy about it, but she went back to my ex and she came back a second time and she said, okay, what about if she claims him 2 years in a row and then you can start claiming him every other year after that? And I said, fine. I mean, I probably could have fought it, but back then the idea of getting this IRS thing resolved with just a stipulation and not having to go back into court, because it's so stressful to represent yourself, it was an appealing idea, so I agreed to it. And I haven't actually taken a careful look at the stipulation, so I'm curious now if that's exactly what ended up coming about. But my memory of it is pretty clear, a little fuzzy, but pretty clear. So why don't we just go ahead and take a look and see what we've all filed. Here we have the stipulation and order. Now this is the first time that my ex and I have entered into an agreement and filed a stipulation. And it's not the last. It does happen a couple more times, I believe. But it is something that is sort of a learning experience for me as a non-attorney, because at this time I didn't know that this was sort of how they did this. I thought everything went to court. I didn't realize that there was a way to get the court to approve something without even having to go. And that's what this stipulation does. The stipulation includes the order as well. For you to do something like this, you have to make sure that you don't file the stipulation. You have to submit it to the court. The court will then sign it and file it itself. If you try to file something like this, the blank line where the judge's signature should be is going to cause it to be rejected. At least that's what I sort of anticipate will happen. The way that my attorney did it was she just had me and my ex sign this document, and then she filed a request for submission and included it as an exhibit. She did something like that, and that you can do it that way because exhibits aren't actual papers, court papers, so the clerks don't really care if something like that is not signed. Anyway, it's one of the ways to get it to the judge and get a signature on it and then have it filed just all as one single document instead of going through the back and forth of filing, and then they file and you file and then the judge files in order and all that. So I wanted to make that clear to my viewers that this is going to be a document that includes our filing, which is the stipulation, and the judge's order all in one. So the first paragraph here indicates that we're going to alternate the exemption, that I'm going to claim it on even numbered years and that she's going to claim on odd numbered years. Now I remember that at this time she claimed them the year prior, so odd numbered years, yep, I was right, so 2009. Okay, so she did end up getting what she wanted. So she had claimed him the year prior, which was the 2008 taxes, and that was a beef that I had, but I ended up just giving in and allowing her to claim the odd years, which would include the year that this stipulation was entered, which means she did get to claim him 2 years in a row, but it's okay because I didn't have to go to court. It was nice to get this done without any stress. I'm not sure that I could really argue in hindsight that I wouldn't have done this because I'd probably be afraid that the judge thought I was nitpicking. Who knows what the judge would really think. Some judges might think it's unreasonable for her to request to claim him 2 years in a row. But in any event, I just didn't want to push the envelope on this and I just let it go. So she did claim him the year prior for 2008, and she went ahead and got the right to claim him again in 2009. But following 2009, we were alternating every other year, and there was no conflict because this IRS Form 8332 made sure there would be no conflict. It pretty much prevented her from claiming him on the years that I was allowed to claim him. So next paragraph here, it looks like, it just specifically states that we are to submit Form 8332. So the first paragraph states that we're to alternate years and which years, go to me and which years go to her. And then the second paragraph states that the way we are to do so is by submitting Form 8332. Paragraph 3 is the standard boilerplate that I've talked before. It's that language that is required to be included in every court order that is filed in a child custody action. And it just says that if you abduct a child, conceal a child, you are going to be punished by category D felony, and there's all sorts of other things that they can do to you. Here's all the signatures. So you can see that I've signed it on the left, my ex has signed it on the right, the attorney has signed it right beneath her, and the judge went ahead and signed it right beneath the attorney. And just like that, you have a order of the court entered by stipulation. We didn't have to go to a hearing. We didn't have to stress out about filing motions and oppositions and replies. Well, I filed a motion, but I didn't have to file a reply. And there is a way to do something like this without even filing a motion. But oftentimes, when it comes to a high conflict X, it is the filing of a motion that triggers the entry of a stipulation. So in this case, that's what it took for me to get this to happen. I do not recommend somebody just trying to work it out with a high conflict X, because what they'll do is drag their feet, and they will offer to work it out with you, string you along for weeks or months sometimes. And in the end, you're not going to end up getting what you wanted until you go ahead and file anyway. If you do file something, it triggers a deadline, and it forces them to make a decision by a certain date as to whether or not they're going to come to an agreement with you. And that's one of the things that works really well in my situation, in my case. Over and over again, I use this method, and over again, I was able to come to an agreement with my ex. The thing is, she needed a deadline. She needed to have her back, in a corner, or, her back to the wall before she would agree to something. And I'm going to go ahead and mention that video. I talk about this in the video delay tactics. So you haven't seen the video. If you haven't seen the video delay tactics, go ahead and take a look at that. I talk about it in detail there. Certificate of service, which is it's just service to me. I'm not even sure that they really had to do that because, I mean, I agreed to it. I signed it, but oh, okay. And we got the next document here, request for submission. This is the vehicle by which my ex's attorney got the stipulation and order into the judge's chambers. It's a pretty common tactic. You can take something that you need the judge to sign that isn't filed, and you can stick it to the back of a request for submission, and that's one of the ways that you can get a document filed even though it doesn't have signatures entered yet. And then the judge can then unstaple that exhibit, sign it, and file it himself as a stipulation and order. So let's go ahead and see if that's what she did. This is something that she did quite often. Oh, I don't see the exhibit. So how did she include it? Well, it says that the stipulation and order be submitted to the court for entry. So even though it doesn't have an exhibit line, that's the way she must have done it. I suppose there's another way that it could have been done. She could have had a runner go all the way to the courthouse, and that runner could have gone to the courthouse and filed this request for submission and handed a paper copy to the clerk across the counter. Then they would put it into the judge's box, and eventually it would get up to the judge's chambers. I'm not sure why they would do it this way, because it would be more expensive for the client to have to send a runner into court. But what I was mentioning earlier about attaching it as an exhibit to a request for submission, that is something that I'd seen done quite often. So I'm surprised that she didn't do it this time, but I suppose she just wanted to drop it off by hand to the judge's chambers. So I'm going to go ahead and move on to the next document. Here we have the notice of entry of order, and this is a document that I've gone through several times. If you want to know more about the purpose behind a notice of entry of order, please watch my video, Notice of Entry of Order. I'm just going to state right now very briefly that this impacts the timeline as to when an appeal has to be filed if a person is going to file an appeal in the first place. The notice of entry of order is when the clock starts ticking. And then the next page just says that she mailed it to me. And then the next page is the index of exhibits, which contains the stipulation and order as exhibit 1. I'm not going to go any further because this exhibit is the exact same stipulation and order that we already went through earlier in this video, so there's no point in doing that. And if anyone's curious, I've mentioned this before, but you can always go down into the description below and click on the links to download these documents just in case you want to see them for yourself. Same thing here, if you would like to take an extra look at this particular document and look at exhibit 1, you can go ahead and do that by clicking on the link down in the description below. Going into the aftermath, I prepared, well, I didn't even really prepare it. I just had to review it and sign it. I reviewed and signed a document, but I didn't file anything, so I incurred $0 in costs. My ex's attorney filed 3 documents, the stipulation and order, the request for submission, and the notice of entry of order, but all 3 of those documents are free, so she also incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, let's go through the quicker documents first. The notice of entry of order and the request for submission, both of those documents are just form documents. I'm going to say 5 minutes for both of those documents. When it comes to the stipulation and order, it's tricky because I need to include the time that my ex's attorney spent on negotiating, not just preparing the stipulation and order. She probably took 15 minutes to prepare that order. And I'm going to say 40 minutes to go back and forth with me and my ex, the sort of negotiation process, which is going to bring it to 55 minutes. So 40 minutes for negotiations, communication, 15 minutes for preparation of the stipulation and order. That does come to 55 minutes. Okay. And then the other 2 documents, which are just lumped in at 5 minutes. So we're looking at 1 hour for my ex's attorney to charge my ex an attorney fees. So that's going to be $250 in attorney fees for my ex. If you have any questions, feel free to post them down in the comments below, and I will see you guys next time.